All right, Ms. Palafu and Mr. Grable, we have Mr. Olnhausen logged in. Are you ready to proceed with his case?
We are, Your Honor. Good morning.
Good morning, Your Honor. Yes.
Let me move him over from the waiting room. All right, we are on the record then in file 22-21196-FC, People versus Andrew Olnhausen. We have a motion hearing and a pretrial scheduled for today. First, let me ask, are there any pretrial issues we need to discuss today other than the motion that's pending?
I just wanted to put a couple things. I had been speaking with Mr. Amadeo. Mr. Grable, if you could please just let him know that there is a USB at the Adrian Police Department for him to pick up. It will be ready at 11:30. He was having some trouble opening some of the videos, so I put all video on a USB for him, and it's available there for him to pick up at 11:30.
At the Adrian Police Department, I will. Thank you.
No problem. Thank you. And then I also wanted to let the court know that I did extend an offer to Mr. Olnhausen, and at this time, he does not want to take that. I am still talking with Mr. Amadeo regarding the offer and regarding a polygraph, which Mr. Olnhausen has a statutory right to.
Thank you.
All right, and I apologize. I forgot to ask the attorneys to identify themselves for the record. So Ms. Palafu, if you want to go ahead and do that.
No problem. Sorry, I forgot myself. Melissa Palafu on behalf of the people, P74121.
Good morning, Your Honor. Attorney Scott Grable, P53310 on behalf of Mr. Olnhausen, Grable and Associates Law Firm. Thank you.
All right, Mr. Grable, anything to address from your side other than the motion?
No, Your Honor. I appreciate the prosecutor's comments concerning the discovery and the communication between our office and the prosecutor. There's been no issue, so I appreciate that. Thank you.
All right, so this is a case that was bound over back in December, so it's been 7 months now since bind over, and it's my understanding from Ms. Palafu today that she's made an offer that's not been accepted. So my inclination at this point would be to set it for trial. It's getting some age on this case, and I think it's appropriate this time to set it for trial unless there's a compelling reason not to.
I have no objection to setting it for trial, Your Honor. But I don't know what Mr. Amadeo's schedule is, so I don't know if I'm not sure.
We have no issue, Your Honor, if the court sets it for trial. I do. Mr. Amadeo is in trial this week. I know he's in trial next week as well. But I mean, obviously, if the court generates a date, I just don't want to call your office and have to reschedule it. So I do want to just confer with him, but we can certainly do that. Or if the court wants to generate an interim date, I'll certainly accept it, of course.
All right, my guess is we're probably looking into November for this case. How many days are we going to need to try this one?
I would say it probably would take 3 to 4 full days.
I concur.
All right, Francis, if you're there, could you find for us 4 days for a criminal jury trial? And those should probably be clean days so that it's not a backup to anything.
Yes, Judge.
And Your Honor, could we also just get like another final conference date before the trial date? Thank you.
Yeah, we'll give you a final pretrial a week or 2 weeks ahead of the trial.
Thank you.
You could do November 28th, the 29th, the 30th, and December 1st.
Those dates are acceptable to us, Your Honor. Thank you.
They work for the people as well, Your Honor.
Let's set a final pretrial then for November 15th at 8 a.m. And the court will issue a scheduling order that we will send out. Mr. Grable, obviously, if you speak to Mr. Amadeo and that date conflicts with something he's got, let us know as soon as possible, and we can get everybody together to find a different date.
I will. I'll let the court know about that forthwith. I'll be speaking to Mr. Amadeo today.
Very good. Thank you. All right. So that then brings us to the motion for bond modification. Mr. Grable, if you have oral argument on that motion, you can proceed with it now.
Very, very briefly, Your Honor. Obviously, it's outlined in the motion in brief, which I incorporate. I'm certainly mindful, Your Honor, that obviously these bond conditions, as far as the amount and the terms and conditions, are somewhat subjective. Obviously, I've been doing this approximately 30 years. We did give some examples of cases that were as serious, or at least more serious, in Lenawee County. And obviously, the financial amount in this case is somewhat disproportionate of the bond compared to the cases in Lenawee County that we cited and that our firm personally handled. And we have, sir, we know what those cases were about because we handled them, and some are ongoing. Obviously, Mr. Oldhausen has been out on bond for over 7 months. There's been no particular issues. I guess what was somewhat frustrating about this case, and we certainly don't allocate fault to anybody, I was in district court early in this case in front of Judge Morgan, and for whatever reason, I couldn't even get a oral argument on the bond. When I was there in person, when Mr. Oldhausen was at the jail, he was in jail for over 6 weeks. He has posted, I believe, a $500,000 bond, cash bond in this case, or it might be a surety bond. There's been, as I said, no issues. He is staying in Monroe County, so he has no reason to even enter Lenawee County. This case, unfortunately, was supposed to be a self-surrender. He did have counsel at the time when he got picked up, but certainly he was no flight risk in this case, which I find somewhat curious. The initial bond argument by the Attorney General didn't even ask for a GPS tether, so I think the Attorney General wanting to keep it on here is somewhat being punitive because they never asked for it initially. So I'm not sure. I don't think there's anything in this case. There's nothing distinguishable from the other Lenawee cases that we cited, where neither of those clients, they were CSC cases. I believe they were CSC1 cases, and there was no GPS tether. The GPS tether is expensive. Obviously, the client has posted a substantial bond. He's turned in his passport. Clearly, this is not going to put the safety of this community or the safety of in Monroe or any other places in jeopardy. Mr. Oldhausen understands, Your Honor, if the court removes the tether and there's even a hint of any type of infraction or technical or otherwise on the bond, he knows he will be put back in jail forthwith. So obviously, he has ongoing medical treatment. To take the tether off for medical treatment, to put it back on, doesn't make a lot of sense. Certainly, Your Honor, he understands he's an educated individual. He's cloaked in the presumption of innocence. Obviously, he's willing to take a police polygraph. I just don't think the tether, other than being punitive with such a high bond, really effectuates really protecting the community or anything else. If not, you wonder why on the other cases. And we only cited Lenawee cases. We could have cited cases all over the state, but I don't think the court really cares about non-tethered GPS cases and other CSC cases outside of Lenawee County. That's why that's why we only gave the court at least a snapshot of some of the cases that we have in Lenawee County. So I don't see any reason that removal of the GPS tether with keeping all the other terms and conditions in place really do anything to harm the purpose of obviously Mr. Oldhausen being out on bond. Also, if the court thinks some additional conditions should be added if the tether is removed, we're not opposed to those as well, Your Honor. As I said, there's been no absolute infractions in any way or allegations of infractions since he's been out. It's running him about $90 a month, $90 a week, Your Honor. And it may not sound like a lot, but after the bond that he posted, it's been a substantial hardship on him. So, and I would ask the court consider that in removing the GPS tether. Thank you.
All right, Ms. Bell.
Your Honor, first, I just wanted to say that this was a stipulated order that we had initially gone into. I can't remember if that was in district court or if that was in this court, where Mr. Amadeo and I had an agreement regarding the bond conditions. And the GPS tether was on there, but there was the exception that if he had to go to Texas and they could not have a GPS tether, that he could then call into the court. I believe he had to make like weekly calls into the court because of the possibility that he might not be able to be on a GPS tether if he was still in Texas. Then he didn't go to Texas, so he was able to be on the GPS tether. But that was part of an agreement that we had initially on this case. And so that was always the people's intention, was to keep him on a GPS tether. I do believe it provides protection for the community and for the victim in this matter. This is a CSE 1 first degree, which could actually be a remand instead of even being out on tether at all. I cannot speak to the other cases. I do not know them. I do not know their history. I do not know the facts in those cases or anything about the defendant in those cases. So I can't speak to any of that. But the people do request that the GPS tether remain on and the bond conditions remain the same.
Mr. Grable will give you a brief opportunity at rebuttal if you care for it.
No, Your Honor. I mean, I'm not privy to the original agreement, but at this particular point, as I said before, Your Honor, not to be circuitous, but after 7 months and obviously Mr. Oldhausen abiding by all the terms and conditions, as I said, he sat in jail for 6 weeks on this. There's nothing that suggests there's been no allegation even before these charges were rendered that there was improper contact with the alleged victim or the alleged victim's family. If anything, it's been the opposite. We were in court. We had to get police escort. Mr. Amadeo had to get police escort to his car. Believe me, I can assure you, Mr. Oldhausen, Mr. Amadeo, myself, we're certainly, none of the parties are going to have contact with the victim's family. We're more concerned that they have contact with us. That's why we needed a police escort, and Mr. Amadeo did, to his car during one of the court proceedings. So I don't think it changes anything, Your Honor. I can tell you he's turned in his passport. Look, just because somebody has a GPS tether, Your Honor, if they want to cut the tether off, people do that all the time and flee. Certainly, Mr. Oldhausen, this does not increase the probability in any way, shape, or form that he's going to be a flight risk. And as I said again, Your Honor, if the court did remove that tether and there was a violation, he understands Mr. Oldhausen would be sitting in the Lenawee County Jail for the pendency of this case till trial. So I would ask the court to remove it. I don't think it's going to change any safety factors, especially with such a high substantial bond that's already been posted with no issues. And Mr. Oldhausen has no criminal record, as I said, and does enjoy the cloak of presumption of innocence. So that's all I'll say. Thank you, Your Honor.
All right. I guess to address one of the last points first, I disagree with the notion that a GPS tether provides no protection because a person can just cut it off and run. At least at that point, we know that it's been cut off and we know to start looking. So I think the GPS does provide a added level of protection. Whether in this case it needs to be analyzed under MCR 6.106F, which sets forth the reasons, or I'm sorry, the considerations when the court sets a bond. Mr. Oldhausen, as Mr. Grable said, doesn't have a prior criminal record. He has appeared at all hearings. That's in this case a bit of a chicken and the egg question. He's been on the tether, so he's attended all the hearings. So the fact that he's attended all the hearings is a bit colored by that. There's no known history of substance abuse or addiction in this case, at least that I'm aware of at this point. there also isn't a known mental condition or any character and reputation for dangerous other than the allegations that are involved with this case. Next consideration is the seriousness of the offense charged, the presence or absence of threats, and the probability of conviction and likely sentence. And that's where the court at least has a little more information than on the other factors. This is obviously a very serious case. Mr. Olnhausen is charged with 4 counts of first-degree criminal sexual conduct. Those are all life offenses. He's charged with child sexually abusive activity. That's a 20-year offense. Use of computer to commit crime, another 20-year offense, and 3 counts of second-degree criminal sexual conduct, which are all 15-year offenses. He has 18 charges in total, but those are the 8 most serious ones. So obviously, this is a serious case. Obviously, this is a case where, if convicted, there would be a substantial sentence. With respect to the probability of conviction, what the court knows at this time is that Mr. Olnhausen has been bound over on these charges, which means that the district court has found that there's probability that these crimes were committed, and there's reasonable probability to believe that Mr. Olnhausen commit these crimes. And so that for me is a significant factor in this case with respect to setting bond. The seriousness of the charges, I think, weigh toward having a significant bond. And that is what we have in this case. I don't know, I haven't heard anything today about his employment status or history, financial history, other than Mr. Grable's comments about the $90 per week GPS fee being an imposition on Mr. Olnhausen. And it does sound like he's staying with family members in Monroe County. So, when I look at this case, and I acknowledge Mr. Grable cited a few other cases, I don't know what the charges were in those cases, how many charges there were in those cases. But for me, I look at each case individually. And when I look at this case, particularly at the seriousness of the offenses charged, and again, knowing that there's been a bind over at this point, I think there's good cause for there to be both a significant bond and the GPS tether. So I'm going to deny the motion to modify the bond and eliminate the GPS tether. I will say that if Mr. Olnhausen needs to have a medical procedure that would be dangerous for him to have the GPS tether on, like an MRI would be. If he needs a medical procedure that GPS is interfering with, it can be removed for the purpose of the medical procedure, but otherwise, I think it needs to remain in place. So that will be the order of the court. Mr. Grable, I'd ask you to prepare an order that's consistent with that opinion, being that this is your motion.
Thank you, Your Honor.
All right. So we have our final pretrial and our trial date. The court will issue a scheduling order with those dates and other deadlines related to the case. So please review that carefully and comply with those deadlines.
Yes, thank you, Your Honor.
Thank you, Your Honor.
All right. Thank you. Then you can go ahead and log out.
Thank you. Have a good day, everyone.
All right, Mr. Daly, I believe we have Mr. Adams at the Lenawee County Jail. We have a jail device that's logged in. It is muted and the camera is off. If there's anyone there at the jail, you're going to need to unmute the device and turn the camera on. For the person that's at JCS Hearings 1, can you tell me your name?
Marquis Smith.
Okay. Sure. Let's see. Mr. Glazer, we have Mr. Smith here. Do you need a breakout session with him?
Just for a moment, Your Honor.
Okay, gentlemen at the jail, you're Mr. Adams?
Yes.
Mr. Daly, do you need a breakout session with Mr. Adams?
No, Your Honor.
All right, we're on the record then in file 23-21392-FH, People versus Jason Michael Adams. We are here today for a pretrial conference and we're proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Muir.
B.B. Mayor on behalf of the people.
James Daly on behalf of the defendant.
And Mr. Daly, where do we stand with Mr. Adams' case today?
Your Honor, today we need to set this matter for trial. There's been ongoing negotiations with the prosecutor's office. I think we're very close to a settlement, but there's a new case that has came up. We just need to get all of these cases put together, and then I think we can resolve this.
All right, Ms. Muir, anything that the people need to address today?
No, I guess I would either ask for another pretrial with all the cases together in September or a trial date in maybe November on this to give time for the other ones to catch up. And to potentially come in with the resolution if we have it.
Okay. So this was just found over in June, so I don't have an issue with another pretrial before setting a trial date unless you do, Mr. Daly.
I don't, Your Honor. I don't know if it's going to be resolved or not, but we're ready to try it if it can't be resolved, but I would like to resolve it if we can.
All right.
September should give us enough time.
All right, so let's set it for another pretrial on September 13th. If it's not resolved at that point, we'll set it for trial. Ms. Muir, would you be willing to prepare a stipulation in order for that adjournment?
Sorry, Judge, you cut out?
I'm sorry, would you be willing to prepare a stip in order, Ms. Muir?
Yes, that's fine.
Okay. All right, anything else to address today?
No, Your Honor.
No, thank you.
Okay, Mr. Adams, you can let the officer that's with you know that you are done with court for today.
All right, thank you.
For Danielle.
Who was telling the judges first? Could we have Daniel Kennedy? Judge, please? Thank you. Bye.
We're on the record in file 23-21425-FH, People versus Marquis Derail Smith. We're here today for arraignment, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Muir for the
B.B. Mir on behalf of the people.
John Glazier on behalf of Marquise Smith, Your Honor.
All right, Mr. Glazier, does Mr. Smith wish to have the information read this morning?
Now we'd waive the reading of that and acknowledge receipt of it. Your Honor, is there just one count? I don't have my file in front of me.
Yeah, there is one count of larceny of $1,000 or more, but less than $20,000. And with that is a habitual offender fourth offense notice.
Okay, he's going to plead to the larceny charge with the understanding that the habitual would be dismissed, but there will be a Killebrew agreement that he is to get 30 months as the minimum, and it will be served concurrently to what he's serving now.
Okay, Ms. Mir, is that a complete and accurate statement of the plea agreement?
Yes, Your Honor.
Mr. Smith, would you raise your right hand, please? Do you
Yes, sir.
swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, I do.
And you are Marquise Darrell Smith?
Yes, I am.
Mr. Smith, you've heard the statements of your attorney and the prosecuting attorney. Is it your intention today to plead guilty to count one, larceny of $1,000 or more, but less than $20,000?
Yes.
You understand that the maximum penalty for that offense is up to 5 years in prison and or a fine of $10,000 or 3 times the value of the property stolen, whichever is greater.
Yes, I understand.
Are you satisfied with Mr. Glazier and the advice that he's given you?
Yes.
Other than, as we've discussed on the record here today, neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Mir?
That's correct.
Mr. Glazier?
That's correct, Your Honor.
Is that also your understanding, Mr. Smith?
Yes, it is.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent at your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Smith, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, I understand.
You also understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right.
I understand.
If you are not a citizen of the United States of America, a conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights, Mr. Smith?
No, I don't.
And do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about August 8, 2022 in Madison Township, Lenawee County, Michigan, you did commit the offense of larceny of $1,000 or more, less than $20,000?
I plead guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
Not besides what was already mentioned. No, nothing.
You're referring to the plea agreement and Killebrew agreement with respect to your sentence?
Yes, the killer Buddha. Yes, yep.
Okay. Do you understand that if I accept the plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record here this morning, or that it was not your own choice to enter the plea?
Yes, I understand.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Smith to plead guilty?
None, Your Honor.
No, Your Honor.
Mr. Smith, other than as has been stated on the record here this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty?
Yes,
Mr. Glazer, do you want to establish a factual basis?
Yes, Your Honor. What was the date again?
August 8th, 2022.
Mr. Smith, on August 8th of 2022, you were here in Lenawee County in the state of Michigan. Is that correct?
yes, sir.
And at that time, you went and took a trailer that did not belong to you. Is that correct?
Yes,
You hooked it up to some sort of vehicle. I forget what kind of vehicle you were
it was
driving.
my van. It was a van.
Okay, and you drove off with that trailer. Is that correct?
Yes, sir.
And it was your intent to permanently deprive the owner of that van and by in fact stealing it. Is that correct?
Yes, sir.
All right. I don't have any other questions.
Mr. Smith, do you agree that the trailer belonged to Stephen Dussault of Dussault Auto Parts?
Yes, yeah.
And do you agree that the value of it was at least $1,000 or more?
Yes,
Okay, I'm satisfied with the factual basis. Thank you.
All right. Has the court complied with MCR 6.302 B, C, and D, Ms. Muir?
It has.
Mr. Glazer?
Yes, Your Honor.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Smith's had full knowledge of his rights to have competent counsel. I will refer this matter to the probation department for an update of your pre-sentence investigation and set sentencing for September 14th at 8:15 a.m.
all right.
Mr. Smith, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Okay, no problem.
And can you tell us the name of the facility that you are at?
Jackson Cooper Street.
All right, I believe we're all set then. You can go ahead and let the officer that's with you, Mr. Smith, know that you are done with our report for today.
All right, thank you.
Thank you, Your Honor.
Thank you. All right, the gentleman at the Lenawee County Jail, you are Mr. Kennedy.
Yes.
All right, Ms. Hennigan, do you need a breakout session with Mr. Kennedy?
No, Your Honor.
Okay, so we are on the record then, file 23-21426-FH, People versus Daniel Martez Kennedy. Also file number 23-21427-FH, People versus Daniel Martez Kennedy. We're here today for arraignment, and we are proceeding today by video conference. First, can I ask the attorneys to place their appearances on the record? Ms. Muir, are you covering this one?
Your Honor, I think she may have stepped out for just a moment, so I can cover it.
Okay, thank you. Then go ahead, Ms. Wagner.
Amanda Wagner for the people.
Samir Hennigan on behalf of Mr. Kennedy.
And Mr. Kennedy is here by Zoom at the Lenawee County Jail. Ms. Hennigan, does Mr. Kennedy wish to have the information read?
Yes, Your Honor.
All right, so this is file 23-21426-FH. People of the state of Michigan versus Daniel Martez Kennedy. State of Michigan, County of Lenawee, in the name of the people of the state of Michigan, prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described above, which is March 3rd, to March 30th, 2023, the defendant, count one, police officer assaulting, resisting, obstructing, did assault, batter, wound, resist, obstruct, pose, or endanger Officer Robinson, police officer of the Adrian Police Department, that the defendant knew or had reason to know was performing his or her duties contrary to MCL 750.81D, subparagraph 1. Felony, 2 years and or $2,000. The consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81D, subparagraph 6, for another violation arising from the same transaction. Group is person, class is G, and then there's habitual offender fourth offense notice. Take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies in that on or about June 2nd, 2017, he or she was convicted of the offense of controlled substance, possession, cocaine, heroin, or another narcotic less than 25 grams in violation of MCL 333.70325, subparagraph A5 in the Third Circuit Court for Wayne County, State of Michigan. And on or about February 8, 2018, he or she was convicted of the offense of controlled substance, possession, cocaine, heroin, or another narcotic less than 50 grams in violation of MCL 333.74012, A4 in Third Circuit for Wayne County, State of Michigan. And on or about February 8, 2018, he or she was convicted of the offense of weapons, carrying and concealed in violation of MCL 750.277 in Third Circuit Court for Wayne County, State of Michigan. Therefore, defendant is subject to penalties provided by MCL 769.12. Penalty, life if the primary offense has a penalty of 5 years or more, 15 years or less if the primary offense has a penalty of 5 years. Maximum penalty cannot be less than the maximum term for a first conviction. Court shall order law enforcement to collect DNA identification profiling sample before sentencing or disposition if not taken at arrest. In file 23-21427-FH, again, the people of the state of Michigan versus Danielle Martez Kennedy. State of Michigan, County of Lenawee, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described above, which is July 5, 2023 in the city of Adrian, County of Lenawee, count 1, controlled substance, possession of methamphetamine or ecstasy, did knowingly or intentionally possess methamphetamine contrary to MCL 333.7403 subparagraph 2B1, felony 10 years and or $50,000. Second or subsequent offense notice, although the people are not required to notify the court or defendant of prior convictions that may result in an enhanced sentence, we are voluntarily informing the court that according to our current information, the defendant was previously convicted of violating controlled substance, possession of cocaine, heroin, or another narcotic, less than 25 grams, MCL 333.7403285, on or about June 2nd, 2017, and therefore upon conviction may be subject to an enhanced sentence under MCL 333.7413 subparagraph 1. Felony 20 years and or $30,000. Count 2, jails furnishing contraband to prisoners. Did bring into a jail, the building pertinent to a jail, or onto the grounds used for jail purposes, methamphetamine, a controlled substance contrary to MCL 801.263 subparagraph 1, felony 5 years and or $1,000. Count 3, police officer assaulting, resisting, obstructing. Did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Castleberry, police officer of Adrian City Police Department, that the defendant knew or had reason to know was performing his or her duties contrary to MCL 750.81D subparagraph 1, felony 2 years and or $2,000. Consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81D subparagraph 6 for another violation arising from the same transaction. Count 4, police officer assaulting, resisting, obstructing. Did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Robinson, the police officer of Adrian City Police Department, that the defendant knew or had reason to know was performing his or her duties contrary to MCL 750.81D subparagraph 1. Felony, 2 years and/or $2,000 consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81D subparagraph 6 for another violation arising from the same transaction. Habitual offender, third offense notice. Take notice that the defendant was twice previously convicted of a felony or attempt to commit a felony, in that on or about February 8, 2018, he or she was convicted of the offense of controlled substance, possession of cocaine, heroin, another narcotic less than 50 grams, in violation of MCL 333.74012A4 in Third Circuit Court for Wayne County, State of Michigan, and on or about February 8, 2018, he or she was convicted of the offense of weapons carrying and concealed in violation of MCL 750.227 in the Third Circuit Court for Wayne County, State of Michigan. Therefore, defendant is subject to the penalties provided by MCL 769.11. Penalty, twice the maximum sentence on the primary offense or a lesser term. Maximum penalty cannot be less than the maximum term for a first conviction. Court shall order law enforcement to collect DNA identification profiling sample before sentencing or disposition, if not taken to the rest. Both of those are signed by Lebanon County Prosecutor Jacqueline Wise.
Thank you, Your Honor.
Ms. Hennigan, have you received copies of the prosecutor's witness list and request for discovery?
I have not, Your Honor.
How does Mr. Kennedy wish to proceed today?
Plea of not guilty on behalf of my client, Your Honor.
All right, court will enter a not guilty plea for Mr. Kennedy on both files. And we'll set a pretrial conference for August 23rd at 8:15 a.m. Anything else we need to address today, Ms. Wagner or Ms. Hennigan?
Your Honor, I just wanted to let Ms. Hennigan know, it does look like we emailed her those documents yesterday. If you don't receive those for some reason, please let me know and we'll resend them.
Okay, thank you. Also, Ms. Wagner, I can't even remember which prosecutor is assigned to this case right now, but we did request the body cam. So if you could maybe send a follow-up note on that as well from the July 5th incident.
Okay, I will. Thank you.
Great, thank you.
All right, if there's nothing else, bond will be continued, and we will see you back for the pretrial conference on August 23rd.
Thank you, Your Honor.
Mr. Kennedy, you can let the officer that's with you at the jail know that you are done with court for today. Can you call for what?
Well, it's county judges. Could we have Nicholas? Please? Thank you.
Mr. Pibbles, do you want to come forward and stand at the podium, please? All right, so we are on the record now in file 23-50575 PP Beth A. Saudi versus Trevor L. Pibbles. We're here today for a show cause order on alleged violation of personal protection order. Sir, for the record, you are Trevor L. Pibbles, correct? Mr. Pibbles, you're before the court today on an order to show cause. That show cause alleges that you violated personal protection order by sending emails and driving past Ms. Saudi. The emails being on May 3rd, 2023, and the driving past her occurring on May 8, 2023. Do you understand, sir, the maximum penalty for a violation of personal protection order is up to 93 days in jail or a $500 fine? Yes, sir. You are entitled to be represented by an attorney here today and at any other proceedings that we would have on this matter. If you're not able to afford your own attorney, you can tell me that and I would appoint one for you at public expense. Do you understand that?
Yes.
Would you like to be represented by an attorney?
Yes.
Do you have the ability to hire your own attorney?
Not really, sir.
All right. So what I will do then is appoint the public defender for you and we lost our public defender who handles these cases. So you will just have a seat where you were. When she gets logged back in here, I will have you speak to her on the iPad that's just outside the door in the hallway. Set it up. The gentleman at the jail, you're Mr. Blevins? Gentleman at the jail, can you hear me?
Yes, I can.
You're Mr. Blevins?
Yes, I am.
Okay. Mr. Glazer, do you need a breakout session with Mr. Blevins?
Yes, I do, Your Honor.
Okay. I'm sorry, I thought I had set that up. Give me just a second. Sorry, Mr. Glazer, I clicked a wrong button. Let me redo this.
All right.
Mr. Daly, I don't see you having another case on our docket today. Did you have something?
I thought I had Drew Levine.
I believe that is Judge Anselm's case.
All right. Thanks, Judge.
Yep, thank you. Okay, I think we're stuck at the moment. Yep. All right, we are on the record in file 23-21218-FH, People versus Adam Daniel DeHaan. We are here today for a hearing on a request of summons for probation violation. We are proceeding both in person and by Zoom today. The record should reflect that Mr. DeHaan was ordered to appear in court this morning at 8:15 a.m. for a hearing on this requested summons for probation violation. It is now 9:12 a.m. and Mr. DeHaan has not appeared either by Zoom or in person here at the courthouse. Based on that failure to appear, I'm going to issue a bench warrant for his arrest. And I'm going to set bond on that bench warrant in the amount of $10,000 cash assured. All right, we are on record in file 23-21355-FC, People versus Nicholas Montgomery Blevins. We are here today for arraignment in this case and also for a pretrial on a contempt of court for failure to appear at arraignment back on May 17, 2023. First, let me ask the attorneys to place their appearance on the record, beginning with Ms.
BB, Mayor, on behalf of the people.
John Glazier on behalf of Mr. Blevins.
And Ms. Glazier, does Mr. Blevins wish to have the information read?
Now, we'd waive the reading of the information, Your Honor. We'd enter a plea, ask the court to enter a plea not guilty. We'd ask the court to perhaps set this for a pretrial on August the 9th. The reason being is he's got 2 new R&Os and they'll be up in circuit court, I think, about on that date, I'm hoping. And I think we'll work this out. And I'm going to have them screened for drug court. I'm going to do the screening before we even come back on the night and see if they can get him screened.
All right, I will enter a not guilty plea for Mr. Blevins and set a pretrial conference for August 9th at 8:15 a.m. And also adjourn the show cause to that date as well.
All right.
Okay, anything else we need to address on this case today, Ms. Muir or Mr. Glazier?
No, Your Honor.
Judge, before, sorry, before Mr. Blevins absconded, the offer put forth to him was to plead to count 2, breaking and entering a building with intent, and dismiss the safe breaking count. That offer would have to change if he's going to do drug court, because I believe one of drug court stipulations is that they do have to plead as charged. So I just want to put that on the record so that Mr. Glazier knows we're going to have to talk about that if he wants to and is accepted to drug court.
All right. Yeah, that's the kind of stuff we can work out. I think he'll be in court next week on the other 2 new R&Os. Okay.
All right. So pretrial on August 8th then, and Mr. Blevins, you can let the officer that's with you know that you were done.
August 8th or August 9th? Should be a Wednesday.
9th, yeah, I apologize.
Okay. All right. Thank you, Your Honor. That's all I have with you this morning.
Okay, thank you, Mr. Glazier, and Mr. Blevins, you can let the officer that's with you know that you're done with court.
All right, thank you.
Okay, Mr. Malero, we're calling for Kyle Choate right now.
Thank you.
Thanks, Judge.
Okay, we are on the record in file 18-19064-FH, People versus Shane Brian Matisse. We're here today for hearing on a request and summons for probation violation. We're proceeding today by video conference and in person. Mr. Stevenson, I received communication from you indicating that you were willing to dismiss this at this time because Mr. Matisse is complying once again. Is that accurate?
Yes, that's accurate, Your Honor.
All right, so at this time, I'm going to dismiss the request and summons for probation violation based on Mr. Stevenson's request.
Thank you.
Thank you, Mr. Stevenson. All right, the gentleman at the jail, you are Kyle Choate.
Yes, sir.
Mr. Malero, do you need a breakout session with Mr. Choate?
Just real quick, Judge.
Okay. Oh. All right, we are on the record in file 23-21381-FH, People versus Kyle James Choate, and also file 23-21435-FH, also People versus Kyle James Choate. We are here today for an arraignment on the file ending in 435 and a pretrial hearing in the file ending 381. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Wagner.
Amanda Wagner on behalf of the people.
Salvatore Malero on behalf of Kyle Choate.
And Mr. Choate is attending by video conference from the Lenawee County Jail. With respect to file 23-21435-FH, Mr. Malero, does Mr. Choate wish to have the information read?
Your Honor, we would acknowledge receipt of the information. We'd waive its reading as to counts 1, 2, 3, 4, 5, 6, and the habitual offender notice. We'd also acknowledge receipt of the witness list. My client would stand mute, ask the court to enter not guilty plea, and set a pretrial date.
All right, so I'll enter a not guilty plea for Mr. Choate on the file ending 435. Are there any issues we need to discuss with respect to the other file that's set for pretrial conference today?
Well, Judge spoke to Ms. Wagner about resolution. I need to evaluate the plea and discuss it with my client. Also, we're going to have Mr. Choate screened for drug court. And so we'd ask to adjourn that as well to the same date as the next case. If we get this resolved, hopefully the court will let us come in early and work it out.
All right, I can set up for a pretrial on August 16th.
That's fine, Judge.
Okay, so August 16th at 8:15 a.m. Mr. Malero, would you do a stip in order for the file ending 381, and the court will issue a notice for the file ending 385?
Yes, I will, Your Honor.
All right, if there's nothing else, then bond will be continued, and Mr. Choate, you can let the officer that's with you know that you're done with court for today.
Thank you, Your Honor.
Thank you, Your Honor.
Could we have Derek King in a room for judicial safety, please? Thank you. Bye.
Okay, Ms. Underwood, we have Mr. Pibbles here on a PPO violation. I think we sent you that information.
Hey, one moment, please, Your Honor.
Sure.
I did receive that, Your Honor. Thank you.
Okay, Mr. Pibbles, if you want to step outside the courtroom doors, there's an iPad out there. I will put you in a breakout session with Ms. Underwood so you can speak to her privately.
Good luck to your new lady.
I don't know if that was relevant to the. Morning, Mr. King. Good.
All right, good morning, sir. You're Mr. King.
Yes.
Sir Dagger Margosian, you need a breakout session with Mr. King.
Your Honor, this is not my case. I'm on Zane Rittenauer.
Oh, I apologize. I wrote that down wrong.
I got Underwood.
Okay, Mr. King, Ms. Underwood is in a breakout session with another client. As soon as she's finished there, we'll get to your case, okay?
Okay, no problem.
Sir Bills, you can come back up to the front.
I don't know, it's been a while.
So we're back on the record in file 23-50575-PP, Beth Saudi versus Trevor Pibbles. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. Pibbles this morning, Your Honor.
Ms. Underwood, you know how Mr. Pibbles wishes to proceed today.
I would ask the court to enter a not guilty plea on Mr. Pibbles' behalf and set this matter down for a pretrial, perhaps in maybe 2 weeks, Your Honor, giving me time to review this matter with Mr. Pibbles and do some investigation.
Okay, so we'll enter a not guilty plea for Mr. Pibbles, and we can set this for a pretrial on August 9th at 8:15.
Thank you, Your
Anything
Honor.
else? Anything else to address today, Ms. Underwood?
No, I don't believe so, Your Honor.
All
Oh,
right.
Your Honor, will the court give Mr. Pibbles a notice?
Yes, Mr. Pibbles, if you want to wait here for your notice, we can prepare that for you and get it to you before you leave. Or we can mail it to you.
If it's quick, I'll wait for it.
It should take a few minutes. Okay. I'll also say that the next date, and I know Ms. Saudi, I think she's still here. The next date is a pretrial conference, so you can attend that by Zoom rather than appearing in person if you prefer to do that. It will be similar to what you've seen in the courtroom here today. If it's not resolved at the next pretrial, we'll set it for a trial. That would be a more involved hearing. Purposes of the next pretrial, you can attend by Zoom.
Thank you, Mr. Pibbles. Thank you, Your Honor.
Okay, and then Ms. Underwood, we have Mr. King here at the jail. Do you need a breakout session with him?
Just briefly, my session ended before I could get to Mr. King, Your Honor.
Okay. We're on the record in file 23-21419-FH, People versus Derek Eugene King. We're here today for a pretrial conference, and we're proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record. And who do we have appearing for the people? Ms. Muir.
BB Mayor on behalf of the people.
And Ms. Underwood, you want to place your appearance on the record?
Rhonda Underwood for Mr. King this morning, Your Honor.
All right. Where do we stand with Mr. King's case today, Ms. Underwood?
Your Honor, I've had discussions with the prosecutor and also with Mr. King. The offer at this point is as charged with a third habitual, the fourth habitual will be dismissed. I need to have further discussions with Mr. King, Your Honor. So I would ask for another pretrial in this matter.
Okay, how about August 9th?
That's fine, Your Honor.
So August 9th at 8:15 a.m.
Your Honor, as to bond in this matter, it's my understanding Mr. King does have a local address. I won't ask him to put that on the record right now. Your Honor, Mr. King is currently on parole with Mr. Face. He is not going anywhere, Your Honor. I believe Mr. King understands the importance of appearing in court, Your Honor, since not only could that jeopardize this case, but it could jeopardize his parole, which I understand is very important. He also would be risking a absconding charge, Your Honor. Mr. King, Your Honor, assured me that he will appear at all court dates. He just wants to be out, Your Honor, allowed to take care of situations he has, and also, Your Honor, to complete probation on another matter. We would ask, the bond at this point is $5,000 cash or surety. We would ask the court consider a PR bond with perhaps 2 or 3 times weekly reports to Mr. Coast, Your Honor. And we believe that would be appropriate. Thank you.
Ms. Muir, people have any response?
Your Honor, I don't think that having Mr. King report to Mr. Coast is a good use of judicial resources, given that he is already on parole, excuse me, and on community supervision. I will say that at the time of this offense, he was arrested for failing to appear, a bench warrant for failing to appear. And he's obviously been charged and bound over after an exam on these charges, one of which is R&O causing injury. He's a habitual fourth with the offer of these charges with the habitual third. I do think he's, and given his guidelines, I think there's a high likelihood that he will receive a prison sentence in this case. So with that, I do think it would be a waste of resources. That being said, I think bond is reasonable as is. And if he posts that, great. But I think a PR would be inappropriate in this case, given the likelihood of conviction and the likelihood of a prison sentence.
All right, reviewing what I can see of the file and having heard what Ms. Underwood and Ms. Muir had to say today, I agree that the bond appears appropriately set. Mr. King has a significant criminal history, although he's charged as a habitual offender fourth. There are 2, 3, 4, 5, 6, 7 items listed in the habitual offender fourth offense notice, some of which is assaultive. And so I think that bond is appropriate as it's set, given his background and given what he is charged with in this case. So I'm going to deny the motion to modify bond.
Thank you, Your Honor. And I will prepare the stipend order, Your Honor.
Okay, thank you, Ms. Underwood.
And I apologize. What is that next pretrial date?
August 9th.
Can y'all even give me a bond reduction? Not even a reduction?
We just discussed that, Mr. King, and I ruled that I think it's appropriate where it is.
I mean, I can pay some. I mean, it's just that high. That's all. I just can't pay it that high.
I'm sorry, Mr. King.
If y'all gave me 10%,
The judge has ruled.
if y'all gave me a 10%, if it was 10%, I could pay it.
Mr. King, I've ruled on the matter, so we're not going to address that further today. You can let the officer that's with you know that you're done with court.
All right.
Hopefully we're bush holding.
I'm done.
Okay, you do for Wendy. Are on the record in file 23-21206-FH, People versus Kevin Brian Berlindy. We're here today for a hearing on a request and summons for probation violation. We are proceeding today by video conference. Record should reflect that Mr. Berlindy was ordered to appear here today at 8:15 a.m. to respond to the summons for probation violation. It is now 9:48 a.m. Mr. Berlindy has not appeared either in person here in the courtroom or by video conference. So I am going to issue a bench warrant for his arrest, and I will set bond on the bench warrant in the amount of $10,000 cash or surety.
How you doing? I'm blessed. I'm alive, man. Mr. King, back to you, sir.
Okay, Mr. Malero, do you need a breakout session with Mr. Polling?
Yes, Judge.
Heading to the rest of us for be downstairs, so we were wondering if there was any. Perfect, thank you. Bye.
She texted me last night, she's like, hey. We have all one, not this week and the next week. And then I work from the night, so. How many people were on? There's nobody on our shift. Next week?
We are record now in file 23-21326-FH. People versus Bush Paulding. We're here today for a trial conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. Meir.
BB Mayor Map the people.
Salvatore Malero on behalf of Bush Paulding.
Okay, Mr. Valero, where do we stand with Mr. Paulding's case today?
Your Honor, Mr. Paulding has a pending matter in circuit or district court scheduled for preliminary examination on Monday. So I would request that we adjourn this file to, if that gets bound upstairs, then I think we can, at least for the purposes of discussion, put them together.
Okay, all right, so we'll set it for a pre-trial on August 9th, which I think would be the day you'd be here for arraignment if he's bound over on Monday. So August 9th at 8:15 a.m.
That'd be good. Thank you, Judge.
Mr. Malero, would you do a stip in order for that adjournment?
I will.
Okay. Mr. Paulding, you can let the officer that's with you know that you're done with court for today.
Okay, thank you.
Thank you, Judge.
Do you have anything else on our docket, Mr. Malero? I don't see anything.
It says I have a William Hollis and a Jade Brown. I'm taking over Jade Brown, Your Honor.
I don't have a Brown on our docket today, but let's call for Williams.
Jade Brown's a violation of probation.
That's Judge Angelo's.
Oh, once again, they throw me a curve.
Yeah, I think I did the arraignment on that one, but it was her case.
Okay, thank you.
So we'll call for Mr. Hollis right now. Oh, I'm sorry. Yeah, actually, Mr. Hollis is not at the jail. He just posted bond 2 days ago.
Right.
And he is not here in the courtroom.
Judge, let me see if since he posted bond, let me see if I can contact him if that's okay.
Okay, yep. And we'll call for his name now. Sorry. Yeah. Okay, we are on the record in file 20-47433-DS, Santana Maria Capitillo versus Richard Joe Capitillo Jr. We are here today for arraignment on a bench warrant, and we are proceeding today by conference. Sir, you are Richard Joe Capitillo Jr.?
Yeah.
Mr. Capitillo, the bench warrant alleges that you failed to appear in here in this court for a show cause on child support back on May 1st, 2023. The original show cause indicates that you have a monthly child support charge of $649 and arrearage in the amount of $10,636.03. Do you understand that?
Yes.
Do you understand that it's a crime to fail to pay child support to the very best of your ability up to the amount ordered?
Yes.
Do you understand that it's a crime to fail to appear here in court when you've been ordered to appear?
Yes.
Do you understand that if you pled guilty to any of these offenses, that I could sentence you to jail for up to 35 days?
Yes.
You are entitled to have an attorney represent you here today and at any other proceedings that we would have in this matter. If you can't afford an attorney, you can tell me that now and I'll appoint one for you at public expense. Do you understand that?
Yes.
Would you like to be represented by an attorney?
Yes.
Do you have the ability to pay for your attorney?
No.
All right, so I'll appoint the public defender's office. We have Ms. Underwood here. I will put you in a breakout session with Ms. Underwood.
Okay.
Okay, Mr. Ridenour, I think we had Mr. Dagger Margosian, but he, oh, hang on, Ms. Underwood, I don't know what happened. Let me move you over to the breakout. Okay, so Mr. Ridenour, Mr. Dagger Margosian apparently logged out of our Zoom session. I assume to go over to Judge Anselm's court. Let me see if we can get him back here.
Yes, sir.
Yeah, he could. All right, we have Ms. Underwood and Mr. Captillo back from the breakout session. Ms. Underwood, do you know how Mr. Captillo wants to proceed today?
Mr. Capitello wishes to plead guilty, Your Honor.
All right, Mr. Captillo, would you raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
Do you understand, sir, that you have a right to a trial and you can't be convicted at that trial unless the evidence against you proves that you are guilty beyond a reasonable doubt?
Yes.
Do you understand that you're entitled to have all the witnesses against you appear at your trial? You or your lawyer could ask those witnesses questions, and you also have the right to have order any witnesses that you have for your defense to appear at your trial.
Yes.
You are not required to say anything at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes.
On the other hand, you also understand that you are entitled to testify at your trial if you wanted to testify.
Yes.
How do you plead to the charge that you failed to pay child support to the very best of your ability up to the amount ordered?
Guilty.
And how do you plead to the charge that you failed to appear in court on May 1st, 2023 for your show cause hearing?
Guilty.
So you agree that you have a monthly child support charge of $649?
Yes.
And
Yeah, there's a little breeze.
back in May, on May 1st of 2023, when was the last time you made a payment at that point?
I paid when you told me to the 189 something, and then I got a job, and then they took money out again. So I made another payment, but I got laid off of that job. I was trying to find another one.
All right, and you were aware that you were supposed to appear on May 1st, 2023 for your show cause hearing?
Yes.
And you agree that you did not appear here either in person or by Zoom at that time?
Yes.
All right. I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Captillo's had full knowledge of his rights. He's had competent counsel. Ms. Underwood, do you want to say anything on behalf of Mr. Captillo before the court passes sentence?
Your Honor, Mr. Capitello is looking for work. He's in a catch-22 where, you know, when you have warrants, it's different. It's difficult to find work, and when you can't find work, you get warrants. I would ask if the court would possibly consider releasing Mr. Capitello and setting sentencing for 2 weeks out, Your Honor, and see where we are as far as bond and payment before any more jail, Your Honor. As far as payment and of job, Your Honor.
All right, Mr. Captillo, is there anything you want to say on your own behalf before the court passes sentence?
No, Your Honor.
All right. So in this case, the warrant was not issued because Mr. Captillo couldn't find work. The warrant was issued because Mr. Captillo did not appear for his show cause hearing. The court, in a previous show cause issue, extended Mr. Captillo numerous opportunities to find work, and really, in my opinion, kind of bent over backward and extended him more opportunities than most people get. And ultimately, we're back here again and had a failure to appear. And so I think that giving Mr. Captillo an additional opportunity at this point, given the history we have in this case, is not appropriate. So it's going to be the sense of the court that Mr. Captillo serve 30 days with the Lenawee County Jail. Credit for, were you arrested yesterday, Mr. Captillo?
Yes.
Credit for 1 day served. All
Thank you,
right,
Your
so
Honor.
that is all for today. Mr. Captillo, you can let the officer that's with you know that you're done with court for today.
All right, thank you.
Thank you, Judge.
Thank you, Ms. Westwood. Mr. Malero, were you able to have any luck contacting Mr. Hollis?
Judge, I called a number in our file and suggested he zoom in, but I have not heard back from him. So I would ask, I don't know how much more you have on your schedule, but if I could go do a couple cases in Anzalone's court, and if he hasn't called in, I guess we'll take the next step.
All right, did you speak to him or did you leave a message?
I left a message. And it was in English, so I think that's his preferred language, so I think he heard it. If he took
All right. Yeah, okay, so yeah, I will, I'll wait a little bit on this one if you want to go handle your cases with Judge Anzalone.
Yes, I'll try to come back in about 15-20 minutes, Judge.
Okay, and if you happen to see Mr. Dagger-Mergosian while you're over there, could you let him know we have Mr. Ridenour in the jail room for us?
Yes, I will do so, Your Honor.
Thank you very much.
Judge, I did want to let you know that we currently have a warrant for Mr. Bahi, so you can take him off of the list.
Okay.
He's on the first
Yeah,
page.
sorry.
Okay.
I did miss that, so. But we haven't for.
Is our office on that?
Oh, okay, so no, so he was set for he had a summons for probation violation that was set for today, and then in the meantime, get a warrant for some additional criminal behavior, it looks like, so he was supposed to appear today, so let's go on the record for that real quick. All right, so we're on the record in file 22-20927-FH, People versus Derek Mitchell Walkie. We are here today for a hearing on a request and summons for probation violation. Mr. Walkie was ordered to appear here today to respond to a summons, ordered to appear at 8:15 a.m. It's now 10:13 a.m. Mr. Walkie has not logged in to the Zoom session, and he is not present here in person in the courtroom. So Mr. Baki's failed to appear. I'm going to issue a bench warrant for his arrest, and I will set bond in the amount of $10,000 cash or surety. Oh, Mr. Skinner, is your case, Ms. Underwood?
It is, Your Honor.
I guess so, yeah. Mr. Murphy, we have Mr. Woolley here in the courtroom, so do you need a breakout session with him?
Please, Your Honor.
All right, Mr. Woolley, if you want to step outside the courtroom doors, there's an iPad out there. I will put you in the breakout session with Mr.
Thing, we don't wait for his attorney, so in the meantime, can we take him out and put an entrance stamp, please? Great, thank you so much. Bye-bye.
Okay, 1 second, Mr. Woolley.
Waiting for your attorney to show up, so we'll just have you come back when he gets here.
Okay, Ms. Underwood, do you need a breakout session with Mr. Skinner?
Just very briefly, Your Honor. Thank you.
Mr. Murphy, are you ready to go on the record with Mr. Woolley?
Yes, Your Honor.
Okay, Mr. Woolley, you want to come forward and stand at the podium, please? We are on the record in file 23-21329-FH, People versus Javius Tremaine Woolley. We are here today for a pre-trial conference. In this case, we are proceeding today by video conference and also in person. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Mayer.
Phoebe, Mayor, on behalf of the people.
Matthew Murphy, appearing on behalf of Mr. Woolley.
And Mr. Murphy, where do we stand with Mr. Woolley's case today?
Yeah, and I'm asking for another pretrial. I apologize. I haven't really been able to speak with my client about the case and what the prosecution's offering. So I was asking for just another pretrial, a few weeks, whatever fits the court schedule best and whatever the prosecution would agree with is all we're asking.
Ms.
Yep, and that's fine, Your Honor. I know there was some confusion about where Mr. Woolley was for a little bit, so we're fine with that adjournment.
All right. How about August 16th at 8:15?
That works fine for the defense, Your Honor. Thank you.
Mr. Murphy, would you prepare that stipulation in order?
Yes, Your Honor.
Thank you. All right, Mr. Woolley, so your next date is August 16th at 8:15 a.m. You can attend that either by coming here in person as you did today, or you can attend by Zoom. The bailiff will give you Zoom information if you want to do it that way. All right, great.
Mr. Woolley, can you just call my office later today or tomorrow and try to schedule an appointment, please?
Yes.
Thank you.
Okay, Ms. Underwood, are you ready to go on the record with Mr. Skinner?
I am, Your Honor. Thank you.
All right, this is case 21-20472-FH, People versus Patrick Lee Skinner. We're here today for a pretrial and probation violation. We're proceeding today by video conference. Ms. Underwood, you want to place your appearance on the record?
Rod, I'll do it for Mr. Skinner this morning, Your Honor. Thank you.
And where do we stand with Mr. Skinner's case today?
Your Honor, Mr. Skinner has a preliminary examination scheduled for August 1st downstairs. So we would be requesting a date after that, Your Honor.
So August 1st. Okay, so we'll set that then. We'll adjourn this pretrial to August 9th at 8:15.
That's good,
Which
Your Honor.
is my best estimate of what the arraignment date would be if he's bound over.
Thank you.
All right, Mr. Skinner, you can let the officer that's with you know that you are done with court for today.
Okay. You guys have a good day.
Thank you.
I will see you this afternoon, Your Honor.
Okay, thank you, Ms. Underwood.
Thank you.
And so you can call from Mr. Hernandez.
We just finished with you. All right. Yes. Thank you. Bye.
Mr. Murphy, do you need a breakout session with Mr. Hernandez?
Please, Your Honor. Thank you.
Okay, 1 second. Okay, I just got an email from Ms. Muir. She's having some internet issues and she's working with IT, so we don't have a prosecutor right now, but as soon as she gets logged in, we will get started with Mr. Hernandez's case.
Yes, Your Honor, thank you.
Yeah. We're just saying he's being loud and like, you're being loud. What you do? He's the one. I mean, besides. He does that in the morning, everybody kind of sleep. No? I said, I know, he ain't never gonna get off. The only role is usually annoying at home, where in front of you know, yeah, like in that after service, like, the past 2 days, but other than that. Well, no, yeah, I was like, Graham wanted to confirm me that. And it's all the, whether I think workers, I must know, I work every day, all day. Yeah, it's possible. I know, whenever I take down the car, I make sure that I did. I mean, I go, I'm definitely 1 year, so like, even the speaker is shit when they announce, I don't hear about that, so it's possible. I got, one time doing this screen problem, speaker has to check, so that way we can track it right on. I'll tell run the same thing. I actually do have a vague memory of they could get on. They didn't get there earlier today. Got, look, I do. Yeah. Vague memory. I got it. Yeah, well, I usually do what I ask.
looks like we're ready to proceed then on Mr. Hernandez. So we are on the record in file 19-19402-FH, 21-20357-FH, 21-20358-FH, 22-20890-FH, and 23-21407-FH, all people versus Nathan Robert Hernandez. Also found under 20-48017-PP is a case where Mr. Hernandez had a bench warrant for a failure to appear. So I need to address that as well this morning, but let's start with the criminal cases. Let me ask the attorneys to place their appearances on record, beginning with Mr. McCready.
Tanner, I don't believe this is my case.
Oh, I apologize. Ms. Mears, is this your case?
Yeah, I can fill in for it. Phoebe Mir on behalf of the people.
Matthew Murphy, appearing on behalf of Nathan Hernandez.
All right, and Mr. Murphy, where do we stand with Mr. Hernandez's case today?
Yes, Your Honor. We are here today. It's actually, I guess, an arraignment on file 22-20890-FH. On that file, I wanted to place on the record that was the file that Your Honor had remanded back down to district. We have proceedings down in district court. It is now back in front of Your Honor. I don't have any updated information, witness list, or discovery demand other than what the prosecution had previously provided on the case. I just want to place on the record to make sure that if there are any changes to it, that I would ask that they make those changes. But again, I just have what was previously submitted on that case. At this time, we're asking for a jury trial to be scheduled. Speaking to Mr. Fleming yesterday, the offer on that file would be for Mr. Hernandez to plead to a domestic violence third offense with a third habitual notice. So they will be dropping the fourth habitual, but there'll be a third habitual notice on that. So again, Mr. Hernandez wants to schedule a jury trial, and we're asking for it to be as fast as the court could find a schedule to do so. And then I guess everything else that's up in front of Your Honor today stems from the incident that spawned that felony. So obviously we're asking, we want to address the violations of probation, the PPO allegation. I hope we could address it that day, but obviously depending on how long a jury trial takes. So I guess we could schedule a pretrial for the jury trial and proceed on those accordingly. Now, I guess Your Honor indicated that there's an outstanding bench warrant for failing to appear. I guess we need to get that taken care of. I believe Mr. Hernandez has been in custody for a few months now, at least.
Yeah, I'm a little confused on that one myself. So, let's start with the rearrangement file 22-20890-FH. I'll enter a not guilty plea for Mr. Hernandez on that file. You waive the reading of the information, Mr. Murphy.
Well, Your Honor, again, that's why I was just wondering, is it the information that we already currently have, or if the prosecution was going to provide a new one? I mean, we would waive a reading of the old information that we received back previously. I just wanted to make sure it was clear on the record that I had no updated ones since the case.
Okay.
It's the same. It hasn't changed.
So we acknowledge receipt of that information, the witness list and the discovery demand. So we would waive a reading of those at this time.
All right. So how many days will be needed for a trial?
I believe maybe one day, it might even be half a day, but I'm hesitant to say half a day because things can drag on, but one day should be sufficient.
I would say one day, and this is Mr. Fleming's case, and I know he has some availability in September if the court that'd be a pretty quick trial date if everyone's okay with that.
We'll be fine with that, Your Honor.
All right. Francis, could you find us a one-day criminal jury trial date, please?
Yes, Thursday, September 14th at 9 a.m.
That worked for the defense, Your Honor. Thank you.
That works for Mr. Fleming.
Okay, so September 14th, I'm sorry, Francis, I missed the time. Is that 9 a.m.?
9 a.m., yes.
Okay, and so how about a final pretrial on the Wednesday before would be September 6th at 8:15.
Yes, Your Honor.
And so do we just want to set his vops for that September 6th date?
Yeah, we'll set all the other files for that same September 6th date.
Thank you.
And, okay, so on the PPO file 20-48017-PP, so the failure to appear in that file is for failure to appear at a pretrial on February 22nd, 2023. It looks like he had warrants in all his other files for failure to appear on the pretrial on that date, and it just looks like that this file didn't get, we didn't do an arraignment on this file when we did the arraignment on all the other files, if that makes sense.
Yes, Your Honor.
So Mr. Murphy, how do you want to proceed with respect to that one? I assume just enter a not guilty plea and set it for the same date.
If we could, please, Your Honor, that would be the best thing to do, I believe.
All right. So enter not guilty plea on that alleged contempt and set a pretrial for September 6th at 8:15 on that one.
Thank you, Your Honor.
All right, Mr. Hernandez, you can let I'm sorry, is there anything else we need to address today, Mr. Murphy or Ms. Meir?
No, Your Honor.
No, thank you.
Okay, Mr. Hernandez, you can let the officer that's with you know that you are done with court for today.
Thank you, Your Honor.
Thank you, Mr. Hernandez. You have a good day.
No.
Your Honor, I think that's all that I had scheduled left. I was gonna go ahead and log off now. That's okay.
Great, thank you, Mr. Murphy.
Have a good morning. Thank you.
Yes.
Judge, when I was having my internet issues, were there any that got taken care of?
No.
Okay. Just making sure. So we were still waiting on Michael for Zane Rittenhour?
Yeah. And Mr. Malero, did you have any luck contacting Mr. Hollis?
Yeah, Judge, no luck on this end. I'm really sorry. I tried.
Okay, let me. No. I guess he wouldn't have another failure to appear because he was in jail up to that point. So we can go on record for file 23-21407-FH, People versus William David Hollis. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. McCready.
Good morning, Your Honor. Dave McCready for the people.
Salvatore Malero on behalf of William Hollis.
Record should reflect this matter was set for a pretrial conference this morning, 8:15 a.m. It's now 10:51 a.m. Mr. Hollis has not appeared here in person, and he has not logged into our Zoom session. Mr. Malero, is there anything that you would like to say with respect to Mr. Hollis's whereabouts at this point?
I would, Judge. Judge, I did call the number we had, left a message. I would just say that if he just posted bond, I think you said Monday.
The 24th, so yeah, that would be Monday.
So, I mean, I think it's possible that maybe he has the dates mixed up. I would ask the court to perhaps adjourn this 1 week, see if I can't get a hold of him prior to issuing a bench warrant.
Mr. McCready?
I'm assuming you're at the standard procedure is for persons released on bond to be under the next court.
Mr. McCready, I'm having real difficulty with your audio, Mr. McCready. I'm not able to understand what you're saying. Didn't hear anything now.
Better, Your Honor.
Yeah, let's try that.
That any better?
That seems a little better. Let's give it a try.
Okay, great. We'll leave it up to the court's discretion.
All right, so at this point, I guess I am willing to give Mr. Hollis another opportunity, so I'll adjourn it to August 2nd at 8:15 a.m. I can see how under the circumstances he might have a date mixed up or had forgotten about this, so we'll set it for a week from today and see where things stand at that point. Mr. Malero, would you do a stip in order for that adjournment?
Yes, I will, Your Honor.
Okay, so I think that's everything I had for you, Mr. Malero, and the only thing I have left is Zane Riddenauer.
Great, thank you, Judge. I did tell Mr. Margosian you were in desperate need of his presence.
Thank you, and he logged in, so it must have worked.
All right, someone listened to me for a
Riddenauer, Riddenauer. Thank you. Bye.
Judge, did we cover Harold Outley?
He was a waiver of arraignment.
Oh.
And do you know this is?
9-6.
What about Tyler Travis? He's on page 5.
He must have got taken off our docket. We'll look him up. Just give us
Yep.
a second.
Yeah, Tyler Travis, Mr. Fleming filed a noli pros on that.
Oh.
Oh, that's okay.
Okay. Holly Coaster on page 2. Did we go over her?
That was taken off the docket as well.
Oh.
Was adjourned by SNP.
Jacoby Lyles.
He waived arraignment.
Oh. Okay. Thank you.
Yep.
But we're like the brown mold and stuff. Gotta get one out of it. Yeah, I gotta get one in there.
Okay, Mr. Dagger Margosian, do you need a breakout session with Mr. Ridenour?
Yes, please, Your Honor.
Okay, we are on the record in file 22-20724-FH, 22-20863-FH, 22-21169-FH, and 22-21181-FH. These are all set for pretrial conferences this morning, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Meir.
Phoebe Mayor, on behalf of the people.
Your Honor, Michael Dagger Margosian for Mr. Ridenour.
Okay, and Mr. Dagger Margosian, where do we stand with respect to Mr. Ridenour's cases today?
Your Honor, procedurally, here's the background. I was on 2 of these cases and Mr. Goldstein was on the other 2 cases. Obviously, Mr. Goldstein has withdrawn on the cases that he was on. So our office has inherited those cases. I don't have the discovery on those 2 files. We have put in our request for discovery with the prosecutor's office, as well as seeing if we can get anything from Mr. Goldstein. But on those 2 cases, I'm not ready to. I believe that these cases may all go to trial, but I'm certainly not ready on those 2 files. So my suggestion would be, if the court allows, to allow an adjournment of all 4 of the cases, get them, keep everything together, and certainly by the next pretrial, I will have received and reviewed the discovery. In the alternative, I would think that the best course of action would be to schedule one of the 2 files that I originally had for trial, just to keep things moving. But I would prefer the adjournment of all 4, just because there may still be room to find a resolution here, but that's what I can represent to the court.
All right, Ms. Meir.
Yeah, I would defer to the court. I'm good with anything at this point.
All right, so I do appreciate the position that Mr. Dagger Margosian is in, having been just appointed to the 2, I think, older cases, which would be set for trial first. Other part of that is that these are all very old cases, and at this point we need to get them moving. But I think it does make sense to give an adjournment to all 4 cases, just to allow Mr. Dagger Margosian to get himself up to speed, and then I think at the next pretrial I'd be ready to set the oldest one for trial, unless for some reason there need to be, in my opinion, a really good reason not to. So I think that's fine. Is August 23rd, so about 4 weeks. Is that good? I could do the week before or the week after also. Mr. Dagger Margosian, how much time are you thinking?
August 23rd should be fine.
And maybe we can get with Francis before then and get trial dates for everything, just so we're ready to go.
Yeah, you're certainly welcome to call and see if that can be arranged if you want to do that. So, all right, so August 23rd then at 8:15 a.m. Mr. Dagger Margosian, can the PD's office do those stipend orders?
Yes, Your Honor.
Anything else we need to address with these files today?
No, Your Honor, thank you.
No, thank you.
All right, so Mr. Ridenour, you can let the officer that's with you know that you are done with court for today.
Okay, thank you, sir.
Thank you. All right, I believe that is everything we had for this morning.